Hi everyone, and welcome to week 4. So this week we're going to review the legal perspectives of surveillance efforts to support public health. And then I want to just tell you a little bit about the emerging transdisciplinary approach to public health law. So by now you can well imagine the legal issues that arise in the collection of data on individual people and the substantial privacy issues that arise, as well as, I might add, confidentiality and security of the health and other personal information that gets collected. So you might be aided in thinking about all of these information-related topics if you keep in mind the purpose for which we are collecting and using people's health or personal information. So remember that the Constitution, either the U.S. or the state constitutions, protect us from government intrusions. And we're going to discuss how courts have defined our constitutionally protected right of privacy and how government surveillance data does or does not intrude into those constitutionally protected rights. But laws such as HIPAA apply to any person or entity, including non-government private entities like health systems or health insurers that collect and use our protected health information. So those HIPAA laws, but the federal and state HIPAA laws, mandate that protected health information remain confidential, and they of course require consents from patients and impose penalties on the organization if companies don't maintain adequate electronic and other security to uphold those confidentiality requirements. And then there's the common rule. So that's the federal law that protects all of us against the use of our bodies or our information for purposes of research. So there are some interesting recent changes in the common rule that raise questions about how that information can be used. And we'll talk a little bit about that. So all of those topics intersect with the legal system. Well, they intersect with lots of systems, but for our purposes, they intersect with the legal system, which then allows some of us, either patients or just as individuals, either redress or compensation if there are violations of privacy, confidentiality, and or security of our information, whether it's health information or other protected information. So I'm going to give a brief overview of each of these topics, but of course your text provides further depth for you. So your text also includes a short review of public health surveillance. And I'm not going to repeat all of that, and if it's been a while since you began the program and first learned about the essential services of public health, you may want to go back and review some of that material. Collecting data on health conditions, either by case monitoring or using statistical surveillance to understand larger public health trends, can be used to create targeted interventions and also to evaluate the effectiveness or the efficiency of interventions. So go back and review some of that material if it will be helpful. But for our purposes, we want to better understand how this kind of public health research and surveillance might interfere with our constitutionally protected rights of privacy. So let's talk about privacy for a minute under the U.S. Constitution. So it will be no surprise to you that privacy means different things to different people and in different circumstances. And the interpretation, frankly, of our Constitution over the years reflects these differences. So primarily it's the 4th and 14th Amendments to the Constitution that are the basis for our constitutionally protected rights of privacy, and that includes bodily privacy, privacy in our homes, privacy of our information. So click on the link to the Constitution that's on Blackboard and review the provisions of the 4th Amendment. Our right to be free of unreasonable searches and seizures by the government, which is the language of the 4th Amendment, that is, our right to be secure in our homes, on our property, that's one type of privacy. And there are, of course, limits to how the government can intrude into our private lives or our private information, or intrude, for lack of a better word, into the care of our bodies when there's no compelling state reason to do so, right? So the 4th Amendment, its limit on unreasonableness, has been interpreted to mean that governments have to have probable cause, for instance, that a crime has been committed before a search or seizure of our person or of our information or of things can take place. So that's pretty straightforward. The 14th Amendment privacy protections are a little less straightforward. And I just want you to understand the basics. The nuances we'll let the lawyers handle. So first, Let me remind you that when the Constitution was first drafted in the late 1700s, it wasn't clear that the Bill of Rights, the first 10 amendments, applied to state government in addition to the federal government. So in 1868, the 14th Amendment was adopted by all of the states to make this very clear. And the language of the 14th Amendment is as follows: no state shall make or enforce any law which abridges the privileges or immunities of citizens, nor shall any state deprive any person of life, liberty, or property without due process of law. So that's the language of the 14th Amendment, and it's very clear that it applies to states. Now, the 14th Amendment does not specifically refer to a right of privacy, and that is sometimes a confusing factor. But the U.S. Supreme Court hinted at a fundamental right of privacy in some earlier cases dealing with, for instance, parents' rights and how they treat their children, the use of birth control by married couples. We have a fundamental right to make those decisions in private. But it was the famous abortion case, Roe v. Wade in 1973, that firmly established a person's constitutionally protected right of privacy. And the specifics of that case were, of course, that women had a constitutionally protected right to have an abortion before the fetus was viable outside the womb. That was the language of Roe. Now, since Roe, the court has relied on that right of privacy in other cases, most recently, and perhaps famously and importantly, the same-sex marriage cases. So now, regarding information privacy, the 1977 U.S. Supreme Court opinion that's excerpted in your text, Wayland v. Roe, establishes a right of privacy for information. Now, in that case, it was information about prescription medication taken by citizens of the state of New York. So the state of New York wanted to collect data on prescription medication because it wanted to manage the use of Schedule II drugs. So that case in 1977 was really at the dawn of the electronic age, and we really didn't yet know how much potential there was for mishandling of computer files. So as a result, the U.S. Supreme Court did decide in favor of the state of New York. It said the state has an interest in managing the use of Schedule II drugs that outweighs an individual's right to privacy in prescription medication information. But the important thing is the case clearly established a right to information privacy. Now, we've come a very long way since 1977, and we now know that information about, who we are, what we do, where we go, what we look like is being collected across platforms, and it can easily get into government's hands and be used against us in all sorts of ways. So the U.S. Supreme Court has taken up some of these cases, but not a lot of them. It has ruled, for instance, that tracking our whereabouts with historical cellular data is a violation of our right to privacy, and I've got a link here to that case, which is Carpenter versus U.S., if you have any interest in that. Now, in the discussion board this week, I've asked you to think more deeply about the limits on government's collection of information about us and the subsequent use of that information for various purposes, including public health purposes. So, we're collecting a lot of health data on all of us, and private health care organizations are collecting that data, forwarding it to governments, and then the government is using that data in all sorts of programs and interventions. And that's all fine, except that there have to be some limits on that, right? Because we do have a right of information privacy. So there are very interesting questions about the necessity of using the collected data and whether that intrusion by the government into our privacy is proportional to the government's needs. In other words, is the government overreaching into our privacy based on the societal need being addressed with the use of that data? So these are interesting questions that I want you to think about in the discussion board this week. So please read Professor Mariner's essay and also Professor Terry's essay in the text on the use of big data. Read all of that before you participate in the discussion board this week. Now, this topic of the use of health information and use by big data is evolving rapidly, as you can imagine. So I want you to, if you have an interest, I've got a link here to this alarming NPR story that's very recent, November 2019, about the use of our personal health data gathered by big tech from devices like Fitbits And I'm very curious to hear your reactions. Maybe some of you are totally okay with that and you understand the health and public health implications of use of that data, or maybe it feels like a very frightening intrusion. But now remember, big tech is not the government. Google, Facebook, Amazon, they are not the government. But, so that means that the Constitution does not apply to the things that they do. But if governments lean on big tech, as they have, to turn over that information, then we may have some constitutional issues. And while I'm not a conspiracy theorist by any stretch, we all know that the actions of government are not all that transparent. We don't have ready access to when government agencies are gaining access to information that we might consider private. So let's just talk a little bit about confidentiality and security. So if you've already taken GPH 733, Health Informatics, you will have learned something about the differences between and among privacy, confidentiality, and security. Now, we've talked about the legal concept of privacy that's protected by the Constitution, but privacy is also protected by federal and state statutes in the HIPAA laws. So the original federal law, the Health Insurance Portability and Accountability Act of 1996, recognized a patient's right to privacy of their health information, and it created a responsibility on healthcare organizations to keep that information confidential. So they have to maintain very strict standards around disclosure and obtain patients' consent to disclosure when that's not otherwise allowed. So confidentiality speaks to the disclosure of information by persons or entities on whom there is a burden to maintain those standards of privacy, either by law or regulation. So security, on the other hand, speaks to the steps taken to maintain privacy and confidentiality, and the non-disclosure of that protected information. So the questions we might ask are what structures and processes are in place to keep that information secure, to keep it from getting into the wrong hands. And while HIPAA does not provide an individual right of action against that healthcare entity or that health insurer, in other words, if my protected health information is wrongly disclosed, I can't sue my doctor or my hospital or my health insurer, but the provider or the hospital or insurance company has to take steps to cure the security problem and may be subject to fines and penalties imposed by the government. So these consequences then act as a deterrent to, hopefully anyway, to carelessness in the maintenance of protected health information. And patients may have other tort claims, like if their privacy is breached by third parties, particularly if it's an intentional act. Some of you may have heard about some of the recent cases where an employee of a healthcare organization or a pharmacy, they've looked into patient records to find out information because there's a private feud. And you can take a look at this recent ProPublica article describing several of these types of cases. And sometimes there's criminal actions brought against those individuals, and sometimes patients have claims under the Office of Civil Rights regulations at the federal level. So if you want to take a look at this, I've got a short video here on information privacy that's on the hhs.gov website. All right, so let's spend a few minutes talking about the common rule. So you've learned about the common rule and its background in other courses, and you're going to get a refresher about all of that in the advanced elective courses as well. So I'm not going to repeat all of that, although if you want to review that information again, you can look at the material on the HHS webpage on the Belmont Report. I've got that link here. It sets forth, the list of ethical principles that govern medical and behavioral research. You can also take a look at this video that's on the HHS website. So your written assignment in week 6 is on recent changes to the common rule. They have created distinctions between use of human subject information for public health research and distinguished it with public health practice. And while that distinction is not always perfectly clear, it's important that you know that there's a basic difference between the two and perhaps learn some of the right questions to ask. So read the text materials on this issue and the assignment reading that's linked in the assignment in week 6, and you get a better sense of why these changes were made. Not only do governments and private entities need a little bit more flexibility to collect and use data for, quote, the purpose of preventing and controlling disease or injury, that's not contributing to generalizable knowledge, unquote. And that's the common rules parameter for research when it contributes to generalizable knowledge. But there's a lot of collection of data and use of data that does not fit that description, that really is used to improve public health. And that's why that distinction was made. In addition, think about changes in advances in medicine and genetics that now allow us to identify human beings at a very cellular level because we have access to the whole genome. So that ability, that scientific advance, has ushered in the need for greater protection of things like biospecimens, and that's another area where the Common Rule has made some important changes. So when you work on your Week 6 written assignment, be sure to loop back here to Week 4 and review the materials on privacy, confidentiality, and security so you can integrate that information into your written assignment. Now, finally, let's take a few minutes to talk about disciplinary approach to public health. Now, this is a little bit of a pivot, but it's around a very interesting shift in public health law that you should be aware of. So there's growing awareness in public health of the importance of law as a mechanism for driving improved public and population health, and the many activities that lawyers and legal experts engage in to support public health efforts. So this is an emerging paradigm, and I want you to be aware of it. So Scott Burris's recent text on the new public health law takes this cross-disciplinary approach to public health law. The CDC has picked it up, and they've got some links to Attorney Burris's work. His recent text outlines the basis for this cross-disciplinary or transdisciplinary approach. Now, Burris and his colleagues use our history of the seatbelt law as a way to describe the framework of transdisciplinary approach to public health law. So he explains that in the 1960s, consumer rights advocate Ralph Nader started talking about the alarming number of people killed or injured in car accidents. And over time, Nader was able to get the attention of the then head of the National Highway Transportation Administration, William Haddon. And Haddon was dedicated to injury prevention. And he actually developed a matrix framework that included domains like, pre-event, the event of the injury, and then post-event domains. And then he incorporated characteristics of the actor who was involved and the environmental influencers. So that whole framework, has really helped kind of flesh out how we understand the basics of injury and injury prevention. So Ralph Nader's work and William Haddon's work led to new testing approaches for motor vehicle injury prevention, such as the crash dummy tests, that demonstrated the efficacy of seatbelts and seatbelt use and the kind of literal and figurative impact of factors such as speed and other driver characteristics. So Burris's point is that scientists, government regulators, lawyers, auto industry stakeholders, across those disciplines, they work together over a long period of time to experiment with policy. Should we have voluntary policies or mandatory use of seatbelts? What is the impact of education? And were we going to get enough compliance with a voluntary scheme, or did we need something mandated? So we have opted, as you all know, for mandating the installation first of seatbelts in all vehicles, and then over time, state policymakers kind of got on board with all this, and many states have enacted mandatory seatbelt laws. So New Hampshire is the only state in the country right now that does not have a mandatory seatbelt law for adults. So as a result of all of that work, over several decades, motor vehicle accidents declined precipitously, which has, contributed to many saved lives. And now, of course, just in the past probably 5-10 years or so, there's been a little bit of an uptick as a result of cell phone use. And I think there's some industry stakeholders that are wondering whether it's time to kind of restart the policy conversations about installation of safety devices in cars that either turn off certain features on a cell phone so that people are not tempted. I'm not sure where that's going to go, but it will be something to watch in the years ahead. So the point of all this is that It took work across many disciplines, including law, to bring about this enormously effective seatbelt safety policy. And it's not only the people that we need at the table. This transdisciplinary approach has allowed us to integrate not only the specialized knowledge or theories from each of those disciplines, but it's allowed us broad and diverse perspectives and discussions to arrive at the best policy solution. And by best, that can mean many things, right? It can mean most effective, most efficient, most accessible, most cost-effective, most fiscally responsible. There are many aspects to what works best for our society. So if any of you are interested in learning more about this new approach, let us know. We can point you in the direction of more resources. And you might also just be aware that it is covered in the advanced elective for policy if any of you are thinking about ILE projects related to policy. Okay, that's it for this week, and I will see you on Blackboard.